You're listening to the Subrogation Support Network, a podcast from Mathieson, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everyone. This is Ashton Kirsch, your host with the Subrogation Support Network podcast. We've had a brief respite, a break, a delay in the podcast's releases over the last couple of weeks. It's been a crazy time, but we are back at it after this brief break, and we are coming to you today to talk about the hot topic of premises liability claims, largely related to slip and falls on snow and ice. It's that time of the season. I know I'm looking out the window right now from beautiful Hartford, Wisconsin, and the snow is coming down. Once or twice a year, every year, I slip and fall while walking, wherever I'm walking because I can be clumsy. I've yet to fall this year, so that is a good thing. Thumbs up. But ultimately, this is the time of year where we start seeing these claims come about. And it's, I say a hot topic, more like a cold topic. And I think that it's going to be an interesting one for us to briefly go through. Interestingly enough, I did just speak on this today. I had a client reach out a couple days ago and say, hey, can you do a training on premises liability claims for our team? So perfect timing because I had already planned this podcast. And next thing you know, speaking on it all day today. So it's at the front of my mind. And I think that we'll have a good time today talking about this. There's going to be no guest. It's just going to be me speaking at you. So wish me well. I think I could talk with myself for half an hour or so. But either way, today what we're going to do is we're going to talk about really a broad overview. I'm going to run through a slideshow presentation. Obviously, you can't see it, but just picking some of the primary topics that I discussed during my 2-hour training seminar that I did. The important things, right? The general idea, the big thing that I'd like to make clear is, premises liability presentations, or anytime we talk about it, it's incredibly state specific. We could talk for an hour to 5 hours on any one state in what we need to provide, what we need to have to prove that claim up. Everything varies on these cases, right? Everything from the actual law being pursued, right? Is there a safe play statute or is there some actual statutory basis for the claim that creates additional duties? Are we just pursuing a claim under negligence rules? If so, and under the common law, if that's the case, what are the specific rules as to the select individuals, the victim classifications? Every state has a different level of duty that's owed to whomever qualifies under those different designations. Example being Florida, they have invitee, licensees, trespassers. It's the idea of the attractive nuisance. We'll go through some factors there. We'll talk about kind of the basic law, recommendations, tips and tricks on investigating these claims, which is huge. What you can do as the subrogation claims handler to take these cases from the point where it's just it's a slip and fall on ice to get to the point where there is a recovery. I can tell you that every month during the winter, I'm reviewing at least, several dozen slip and fall cases clients are sending me. Typically, these are marked no subrogation or shutdown, especially when they're in, the northern Midwest, places like where I am, Wisconsin, Minnesota, Michigan, where there's a higher standard and it's a lot harder to pursue a claim for a slip and fall on ice because ultimately, we're expected and there's an additional reasonableness standard. A lot of times juries and the fact finder, it's a lot harder for them to, understand the negligence of an owner or responsible party when they're always out there walking on slippery snow on those conditions. So there's also a geographical deviation in how the fact finder, how the juries are looking at these things and awarding on these claims. So I guess the big thing to make note of for anyone handling these cases is it's very state specific. We're going to talk about some broad topics, but obviously any slip and fall case, any premises liability case for that matter, you need to have good counsel, you need to have good experts on board, and you need to understand the law and the local jurisdiction because more than anything else, facts matter here, the facts of the case, but also the way that you prove your case, what you argue and whether you have a viable claim is so important. Another example of that I'll briefly mention is just the contributory fault regimes. What are we applied to? Is this a 50% bar state, a 51%? Are we looking at a pure comparative state where, hey, you could be 90% responsible and you can still pursue the defendant for the 10%. Or a pure contributory negligence state where, they claim it's a 1% bar. If, slip and fall, if the claimant, the injured party, is at all responsible, they can't recover anything. I can tell you that I have successfully litigated slip falls in Virginia and other contrib states, but it's incredibly difficult and most carriers are just shutting them down. So kind of the standard basis of what we're going to discuss today, it's going to be focused on those either pure comparative states or those states where they have a 50 or 51% bar. We're not really discussing pure comparative states pure contributory negligence states in that regard. So all in all, let's jump into it. So slip and falls, basic review of premises liability claims. Let's look at California as an example. At the core of all premises claims really is the requirement that one, that the owner keep the property in a reasonable, safe condition. Two, that they use reasonable care to discover any unsafe conditions. And three, that they fix or repair or warn of any dangers that could reasonably be expected to cause harm, right? California is relatively unique in that it doesn't have a different standard basis for the type of invitee, right? A different victim status based on who you are, how you're there. But many other states, and something that's really unique, that if you just Google premises liability claims, a lot of people's eyes glaze over and they get really confused because it's not the same as just, hey, we look at negligence, right? It's a duty owed, was something violated? Is there a claim? Are there damages? Instead, we're actually looking into what is that duty? How is that duty defined in each state? And that's oftentimes based upon the type of individual that is being injured, right? Are they an invitee, a licensee, a trespasser? And we're going to go into some example of that to get a better idea. So let's look at Florida law. I was just down in Florida recently. It was wonderful. I defrosted a little bit before coming up here to where it's, 30 some degrees. I actually went from the beaches of Florida to a few days later, the frozen tundra of Green Bay for a Packers game where, for my fellow Packers fans here, they did beat the Chiefs. I think they're going to the playoffs, crossing my fingers. But either way, Florida law. So in Florida, there's different designations and different duties owed on behalf of that owner to the various individuals who could or were injured on their property. Designation one is invitee. That would be a person who comes to the property as a customer or at the invitation of the business or individual. For example, in Florida, I paid to go to Disney World, which I did, waited in a lot of lines. If I was injured there, let's say coming up to the top of my head, I'm waiting in line for 2.5 hours for Haunted Mansion. And next thing you know, there's a big divot in the ground. I slip and fall, go into the hole. I'm injured. Disney World owes me a duty as an invitee. Let it be known that those duties vary state by state. There's not just a rule across the board that all invitees in all states are owed these duties. And this is my burden of proof. It differs. But the big thing to understand is on any of these cases, we want to figure out if there's a deviation between the duties owed based on a victim status. What is it? How do they fit in? Now, in Florida, there's also the idea of a licensee. A licensee is a person who comes on the property for their convenience without either express or implied invitation. An example of this, if you're injured in an area, let's say, where you just weren't invited to go, right? You walked into a place that said employee only. You're no longer an invitee, you're a licensee. And the duty of care owed here to a licensee is to refrain from willful misconduct or wanton negligence. You have a duty to warn of dangers that are not open and ordinarily observable, and refrain from intentionally exposing the licensee to danger, right? So licensee in Florida and in many other states fits in between invitee and trespasser. Now, the individual type, the designation that the lowest duty, lowest burden is owed to is a trespasser. And a trespasser is a person who enters the premises of another without license, invitation, or any right to enter that property. That's somebody that comes onto the vacant land or the construction site at night to try to look around, be it for a purpose to steal or just to kind of take a peek. Either way, they know they have no right to be there. And typically the only duty owed to a trespasser is to avoid willful and wanton injury. Much lower standard and ultimately a much higher burden on the plaintiff to prove a case when a trespasser's injured, because that owner has a lower duty. They don't have as many obligations, responsibilities to that individual when they are coming onto the property without permission. Associated with the idea of trespass is also another term that's worth mentioning, and that's the idea of that's the idea of somebody that creates an attractive condition that thereby encourages somebody to come on and trespass on the property. Now, one of those trespassers that come for an attractive issue, what happens there is that has to be a child. It's a way to overcome the trespass rules. For example, in most jurisdictions, there's an exception there. You're not necessarily a trespasser. You can make a claim if there's an attractive condition created. Oftentimes that would be, let's say there's a pool with a beautiful big penguin floaty device. In that situation, that would be an attraction that could create liability and exposure on the owner if a child comes through and is injured in that position. All right. Those are the general ideas of it. Now let's look to Wisconsin law for another deviation, right? Now, obviously, there's going to be different duties owed under negligent, under tort rules per who that individual injured is. Another thing that comes into play is various states and many states distinguish between the duties owed by private owners and those owned by those holding their properties open to the public. They refer to them as public property owners. That doesn't mean that it's a public property as you think of like a government building. It means those buildings, those stores, those locations that are open to the public, right? Private owners, they owe a reasonable duty of care to invitees, persons invited implicitly or explicitly upon the property of another. Public owners and maintenance companies, actually, they owe a much higher duty to people on their property than do the private owners. In Wisconsin, as our example here, like other states, also creates a distinction based on the classes of people injured, as we already discussed. Now, private property owners, their different duty, it's weaker, right? A trespasser has a lower duty on a private property. Same thing as that owner on a public property may have a higher duty. Now, let's break that up a little bit. Now, with regard to non-trespassers, in Wisconsin, again, continuing that example, a private property owner must only use reasonable, ordinary care under the circumstances to construct, manage, and maintain the premises to avoid exposing a non-trespasser to an unreasonable risk of harm. Such private owners in this situation, they have a duty to discover and to make safe conditions on their property that would likely expose a non-trespasser to an unreasonable risk of harm here. If an unreasonable risk of harm existed and the owner knew of it, if there was something that they were aware of that was an unreasonable risk, or that they should have known of it, understand, in most jurisdictions, there's a reasonableness standard here for constructive notice. If they constructively should have known about it, then the owner has a duty to either fix the problem or to warn of the condition, right? When it comes in Wisconsin, there's also the safe play statute, oftentimes applied to employers, to those opening their places up for business and frequenters coming in. And that situation we'll discuss in a few minutes. That's where the public comes in to have a much higher burden on that owner and a higher duty for them to individuals. Now, Wisconsin, like many other states, if you're not applying the safe play statute, if it's a standard just negligence claim, the plaintiff's required to show a few things, right? This is law school 101, right? What is negligence? Negligence would be one. There has to be a duty, meaning that the owner had a general duty to keep the premises safe. That's what we're talking about all here. What is the duty? What do they owe to the injured third party? There has to be a breach in a negligence claim. The owner breached their duty to keep the premises safe in some way, right? Proximate cause, that's obviously relevant. The plaintiff was injured due to an owner's breach of their duty, and there has to be damages, right? You can't make a claim if you don't have any damages. So the plaintiff has to be injured due to the owner's breach of their duty here. Now, it gets really difficult, and a lot of these cases really, circle onto they're centered on a dispute over establishing that breach of a duty. It's about providing evidence that the owner of the premises knew of a defect, failed to take action to correct it, and so forth. A lot of times it comes up to issues such as putting contributory negligence on the plaintiff, right? Should they have been aware of this? Did they take appropriate steps to avoid falling? Let's talk about the slip and fall on ice, right? Did they look around? Did they just get out of their car without their shoes on and just go running across, a snowy driveway? Or did they step out of their tractor trailer, as we see often, with appropriate winter boots on, and then they still fell despite their best efforts? And then we obviously need to dig much deeper into that, because just because you slip and fall doesn't mean that an owner is going to be responsible. They have to somehow be breaching their duty and in some way not be doing something correctly, be it situation where they were aware of the fact that water was running off the downspout onto the ground in this specific heavily trafficked location. They didn't put salt or sand or anything down. Next thing you know, people slip, they keep slipping. At that situation, somebody's going to be responsible. Defense you also often see is called the open and obvious defense, which is a general idea that, if the condition was open and obvious, then it's going to be more likely that the plaintiff is going to have a hard time proving that up because they should have noticed, they should have seen the condition, and they should have avoided it rather than necessarily claiming that the landlord was responsible or whomever it would be. Now, negligence claims, when we're looking into this, when juries really decide premises cases and whether a property owner was negligent for not using reasonable care in that situation, they usually consider just a number of factors, right? There's a lot of things they look into, and it's not across the board, but this is kind of one of those generally applicable things they look at. They look at the type of property and its location, right? What type of property is a business? Is it an individual home, a private residence? Is it a theme park? They look at the likelihood that others would come to this property in the same way, right? Is this open to the public? Do you have frequenters? Did the victim often visit this property? They looked at the likelihood of harm created by the dangerous condition. How likely is it that this dangerous condition would cause harm, right? Was it a simple extra inch in a step that could have potentially caused harm if somebody wasn't paying attention watching down the steps? Or was this just a gaping hole that was covered by, a layer of soot or something that they stepped into, right? There's different levels, right? That's why, again, I mentioned, if you're going to remember one important thing about premises claims, it's the general idea that the facts matter. The facts matter here way more than probably any other type of claim that you're looking into. Whether the defendant knew or should have known about the dangerous condition, which created foreseeability of the risk or harm. And also we're looking into how reasonable or difficult it was to protect against risks that created this dangerous or was created by this dangerous condition. So, that's negligence claims in a nutshell. Obviously, one, look into state deviations. Any specific class of victim, we need to look into what are the duties owed to that type of victim. Can we sustain our burden? What's going to be kind of the practical aspects of the jury in this jurisdiction? Is it going to be a state where it's easy or hard to pursue if it's a slip and fall on ice, and so forth? Now, aside from just standard negligence, different states, right, have rules, have statutes that provide additional protections for specific classes of individuals. For example, Wisconsin has a safe place statute, and many other states have safe place laws as well. And what safe place rules do is, in Wisconsin, for example, it holds an employer or owner of a place of employment to a higher standard than ordinary duty of care under negligence claims. So that's under claims as we just discussed. What it does, it requires an employer to furnish and use safety devices, and really they have to do anything reasonably necessary. The terms are to protect life, health, and welfare of employees and frequenters. Frequenters is an oft-disputed term. You'd have to look into it further. Different states are going to kind of define that differently, but often it's those that are frequently visiting the property in a public place. Also imposes duty on the owner to construct, repair, or maintain the premises upon which the person was injured so as to make them safe, right? It's an additional requirement, a positive duty on that owner to create a safe condition. Right? In Wisconsin, under the safe place statute, the violations here are separated and you'll see two distinct issues, right? It's claimed based on structural defects and those claims based on defects associated with the structure, right? Similar, but one of them involves structural defects, the other, those just associated. A structural defect, if I'd want to try to explain it to you, it's kind of like an unsafe condition on the property that has been built into the property. So in the sense that the structural defect include maybe improper building materials, improperly designed buildings, or even situations where maybe the property wasn't laid out correct or the scope wasn't correct in how this was developed. Examples of this would be maybe steps with no handrail, or it could be steps that were, maybe not designed appropriately to be the right height or uneven. Or it could be the property was designed with a door that opened up to a drop off of 100 feet, right? Whatever it would be, it's the design of the property in general, a defect in the property. Now, a defect associated with the structure means an unsafe condition due to disrepair or lack of adequate maintenance. We see this all the time, right? This would be rather than the stairs were uneven in their design, that the stairs were crumbling, right? One of the stairs was crumbling, or it was a deck that was wooden and it was deteriorating and somebody fell through. I actually just had a case like that a few months ago we resolved. So now the main distinction under Wisconsin safe place law between structural defects and defects associated with the structure is that the injured person is required to prove that the owner of the property was aware or should have been aware of the structural defect, right? So there's an additional standard that you are not required, right? The individual injured is not required to produce proof that the owner was actually aware or constructively aware. So if there was just this dangerous condition and that it's proven that it was a defect in the condition, then there's no duty for, as one of your elements, as the injured party, to prove that they knew about it, even if they didn't know about it, or even if they constructively didn't know about it, or well, even if you couldn't even show they could constructively know about it, you still can prove that claim. However, for those defects associated with the structure, that's the crumbling stairs or whatnot, you'd still have to prove that they were aware of it or should have, which is oftentimes, that's an oft litigated issue. A lot of times it's that crumbling stair. I'm litigating these cases and I have to show that one, that owner, often there's maybe a landlord, whomever it was, that they should have known or they did know that the stairs were crumbling, that there was a maintenance issue, right? Whatever it could be, those are the different standards. Keep that in the back of your mind. Obviously, you're never going to be an expert on all states' laws when it comes to premises liability, but the important thing to remember about that specific issue and why I mentioned the safe place statute in Wisconsin is to provide an example. Every state doesn't have a similar law. Many states do. And if it's statutory, that's what you want to look into. That's why this is so important. And many of your eyes are probably glazing over with this because we've talked about Florida, we've talked about California and Wisconsin, all the different applicable rules and so forth. There's majority rules here. There's a lot of things that apply across the board, static rules and guidelines. But oftentimes the best thing you can do is just have knowledgeable counsel or focus. A lot of the carriers I work for, when they have a large enough operation, they have those folks that focus on the specific states because it's really important to understand how these things play out state by state. Now, on to more on the important start of snow and ice claims. Let's talk about some investigation issues, right? We got a snow and ice claim, right? Slip and fall on ice. What do we do? Well, obviously, with any investigation, we want to do prompt, thorough investigation of the slip and fall. This is more important here than really almost any other type of claim, right? Auto collision, we can kind of recreate it. Many other things we can recreate. Snow and ice, without photographs, without proof, we're going to have a really, really hard time pursuing this case. For example, guess what? Snow, ice, water, it melts, it moves. It may not be there 5 minutes later, definitely not 2 days later. So conditions change. And oftentimes when we're dealing with a slip and fall on snow or ice, it's going to be, our evidentiary burden is only going to be met by getting that evidence now. I'm holding my smartphone in my hand, looking at the time, and right in my hand, I have the power to take videos, photographs that are better quality than what a professional photographer could have done 10 years ago, maybe even 3 years ago, right? The quality of video evidence, video and phone evidence or phone photographs is so high that there's no excuse anymore for us not to be training our drivers, our insureds, whomever it would be, to take those photographs after they're injured. And or we need to be identifying subrogation immediately so we can send someone to the scene. And I have people all over the country. So if you just need a body to go out there and take some photographs, we've got them. And we do that all the time. We have our clients get us those cases immediately, because if you send me a slip and fall on ice and it's, $500,000, 6 months later, you know what? I can probably find some way to dig into this and come up with some sort of reasonable theory. But usually they're not that high. If you come to me 6 months later with no photographs, no evidence, and just say, hey, Ashton, claimant slip and fell on ice, we pay $25,000 in work comp benefits. There's really nothing we can do at that point, aside from beg and hope that somebody has photographs, the defendant location has a video, or there's something there, the police report has something, whatever there could be. But oftentimes that's lacking. That's what these cases fall on. Always, always, always remember, get the photographs, get the evidence immediately. That doesn't mean 5 days later. That means immediately after you become aware of the injury. We want to be looking in these cases and memorializing features or defects in the property which cause the snow or ice to accumulate in a particular location. The best cases that are slip and falls, in my experience, I actually litigated and just recovered almost $1 million on a slip and fall last year. We're at a JPA with the claimant. And the case was, my guy's walking down the stairs, got to the base, slip and fell, and next thing you know, he's severely injured. Well, we look at the case, and what we had was up above, the downspout was broken off, and water is flowing down when it's melting. It's flowing down when it's melting off the roof, and then it's hitting the ground where it's actually in the shade, and then it's refreezing right there. I was able to show that the defendant, they knew of this condition, they knew of the problem, and guess what? People just slept in. They decided it's fine. It's just, one of the employees, they won't slip and fall when they're coming down the stairs. Well, guess what? My employee did. They injured themselves. We were able to prove the case, and it was really a slam dunk. Well, as far as slip and fall can be a slam dunk, it was. But that came down to the fact that we were able to preserve the scene, get photographic evidence immediately. We were able to get examples and get photos of the downspout, how it was working, how it was operating. And in that situation, in other cases, I was actually able to send somebody to the scene immediately afterwards. They scooped the snow right around where the fall occurred. They put it in a big plastic baggie. And guess what we were able to do? And this is unique. I've never heard of many people doing this in the past. We were able to use that later to show that there was no salt in the snow. Because a lot of times that's what it falls on is, owner claims, yeah, we salted it. It was salted. Your guy just slipped and fell. And then we're coming and say, hey, we didn't notice any salt. So there are ways to actually prove and to show there was not salt or insufficient salt utilized at the time. So keep that in the back of your mind. Get involved immediately. We're also looking for evidence of actions on the part of the property owner, which may have caused the snow to accumulate in a particular location, aside from just the condition of the property. So maybe they're pushing the snow right to another place. Maybe they're designating, hey, we're going to start shoveling here. We're going to go over here. We're not shoveling appropriately. We're doing things that are otherwise negligent. We're not handling the removal of snow appropriately. Tough cases, but there's many, many other things that we can do to figure out here and actually create some sort of liability theory here. So act immediately, investigate immediately, and then make sure that we are actually taking the steps that are necessary. All right. On to some other things involving just slip and falls in general. I think we still have some time, so I do want to talk about kind of some tips and tricks, things that I recommend. So obviously, we have slip and falls in many different ways, right? We want to document the condition on anything. Slip and fall on ice, premise liability, fall in a hole, fall down the stairs. We want to get out there immediately to photograph, take measurements. Measurements are huge, right? There's no reason we can't be doing that. We want to talk to witnesses early. Witnesses can be essential in these cases, right? Because a lot of time we're talking about factual issues. What was the condition, right? On a slip and fall on ice case, did anyone else see it being salted? Was it shoveled? What did it look like if there's no photograph? If it's a situation where we've all seen the cases where you're slipping and falling because somebody didn't put out a warning sign when they were mopping the floor, right? Are there any witnesses that can say that? Were warning signs used? We're getting with the defendants immediately. This is another huge tip. If it's a slip and fall anywhere where a camera could have been present, we need to immediately put the defendant on notice of their need to retain that camera footage, because I'll be honest with you, some of the best cases I've had have been those where, they're claiming, oh yeah, we shoveled, we sanded, we did all the above. Oh yeah, we put out warning signs. And guess what? We get that footage. There it is, right there in front of everyone. We have it. So make sure there's no way, we just can't assume that they're going to keep that evidence. We need to let them know, pound it into their mind that we need the evidence, any video recording that's out there. So at that point we can see, timing's everything on these cases. How long was the condition there? Be it that, the water on the floor and no warning sign, or even the ice on the ground. Timing is everything. So we need to know that. We're trying to see if there's notice, that they're on notice of this, any other prior falls throughout the day. We've seen this often where, oh yeah, our guy slipped at 5 p.m. Another person slipped at 3 p.m. Another person at 2 p.m. Another at 11. Oh, but guess what? They didn't do anything. They didn't take any proactive steps. Prior complaints are huge, other conditions. And also we need to take the time to think, right? Premises liability, usually when we think about expert retention, we're thinking about product liability cases, right? Of course, we need an expert for a product defect case, but also premises liability claims, slip and falls, anything like this. These are things where they're just really prime and ready to bring in the right experts. A lot of times the condition is going to be at issue. We need an expert, an engineer, a civil engineer, somebody to take a look at the condition and tell us if it was reasonable. Not necessarily always for slip and falls on ice, though we do have experts we use there. But a lot of times, if it was a condition, a defect in the condition of the property, be it one, let's say those stairs, the steps that were crumbling, or that step that was a little bit few inches off of the others, that's where we want to bring experts in immediately. The sooner the better, because ultimately, as with any claim, the time spent investigating these cases earlier, spending the time, spending the money, spending the effort, it's going to be inversely proportionate to the amount of time and money and energy and effort you spend over the life of the claim. Put the time in early because it takes a lot more time to pay an attorney, to pay the experts, their huge rates, to look into it and recreate the wheel when you can deal so later. Also, early in the claim, in the investigation, there's our opportunity to preserve the evidence, anything we have, if there's anything that's in our control. It's to identify the key players immediately, right? Slip and fall, maybe there's a maintenance company. Maybe there's somebody else. Who knows? There's all these different parties that we need to identify early so we can set up a scene inspection and take a look, inviting everybody. There may be coverage issues, right? This is the time early in this stage, especially with premises liability, where we want to, especially on the work comp side, get all of the contracts between the employer, our insured, and the defendant. Because I can't tell you how many times I've had a case. I get it over. I just had one last week. Client sent it over. It's like $350,000 work comp benefits paid. I take a look at this case. It looks like slam dunk liability. It was beautiful. It was a slip and fall, just like I was telling you. There was no warning sign out there. They were just mopping the ground, left this huge conditions there for like 6 hours, and then they kept going back to clean up another spill. Nothing happened. Great case. But guess what? We look at the facts. We get the contract, request it from the defendant, and lo and behold, right there is waiver of subrogation language, right? There's no right to bring the claim under that agreement. So we're out of luck in that jurisdiction. The client spent, I'd say, 20 to 40 hours on this case working it up, when if they just initially asked for that contract between the parties, they would have realized we were out of luck. So always, always, always get into that. Plus, we should be informing, that should be an inside job by all of our claims teams, should be working with the actual originators of those policies to ensure that waivers of subrogation are very, very seldomly used. We need to inform our insureds, as I present on all the time, as to why we don't want waiver of subrogation language, how essential it is that they not include that language in their contracts with big customers. Typically, experience-wise, when you request for it to come out, it's the easiest thing to take out. It's tossed in there as kind of a template by most parties when there's an agreement. So ask for it to be removed. Tell our insureds that. All right, a few other things before we wrap it up. Important things to just consider is look at the investigation. We want to investigate early. I keep stressing that. Identify those roadblocks, those contractual issues that might come into play. Use as the chance to get all statements, review everything, get all the details. You never know, ever, what is going to be important until down the road. I know that Gary Wickert, one of my partners here, he presents at quite a few different conferences, on investigation and claim techniques. And he always talks about the parable of the pebbles. And I'm going to synopsize it because, there's a whole story behind it. But the story goes like this. You have a group of nomads tracking through the desert. All of a sudden, they come to rest one night and they hear this voice from above, this overarching voice saying, hello, thank you for stopping for the night. I'd like you to look around and find these pebbles on the ground. Pick up the stones, put them in your saddle bag, and tomorrow you will be glad and you will also be sad. And the nomad's like, what the heck is this? I'd expect some huge statement from up above. If this terrestrial being is coming to me, I expect some important something they use in my life, but I was told to pick up stones. Well, whatever. A few of them picked some stones, put them in their bag. The next day, they arrive at their next camp. They go into their saddlebags. They take out the stones, and they've turned to diamonds. Now, the nomads, they were sad because, hey, they didn't pick up more stones, but they were glad because the pebbles had turned to diamonds. Now, it's a much longer story if you give the whole parable, but in the end, I always think about that to think that the evidence in your case, every little stone sitting there on the ground, especially in a premises liability claim, every piece of evidence is a pebble. And guess what? It's going to take many days, many months, maybe even years to figure out which one of those pebbles are going to turn into that diamond. But let me promise you, some of those pebbles are going to turn into diamonds. And if you don't do an extensive enough investigation, you're going to leave the diamonds on the ground and they're never going to be picked up later. So always, always, always do an extensive investigation, document all facts, dig into everything, take recordings, take statements, take photographs, preserve evidence, observe witnesses, take measurements, obtain documents, reports, engage experts, give notice to all parties, get your conclusions in line, write out your summaries of recommendations. I always recommend that, and engage counsel. There's no reason to avoid engaging counsel early, especially on premises cases, because it's really, really seldom that the adverse party is just going to write a check for 100% of your damages when there's a slip and fall, especially on ice in one of those claims. Now, next up, obviously we need to think about, we talked about when to investigate immediately. Now, hiring experts. Typically we talk about this on products claims, and we just actually did a webinar not that long ago on product claims, but I'm going to just kind of recap that. And the general idea is that, we hire experts the when as soon as possible, right? Too many of my clients hold off way too long to save the couple $1,000s, even couple $100s to get an expert opinion. And the next thing you know, they wait to the last minute, 5 days before the SOL, they send me the case. I'm like, hey, you don't even have an O&C on the case, right? You don't have a mechanical engineer. There's nothing we can do for you. We need an opinion. So we need to make sure we bring them in at the right time, especially on these premises cases where they can be utilized. We need to be careful in choosing the right expert. It's not just about getting an expert, right? We can't trust the CV. That's the one thing. I've hired some amazing engineers out of MIT, out of Stanford, out of Ivy League schools who have turned out to be absolute duds. We need to get them on the line, interview our experts, have the conversations, making sure that they have the requisite background. I'm not a huge fan of retaining jack of all trades engineers. Far too often I've actually been like, well, what do you do? It's like, well, I deal with everything. I'm a forensic engineer. It's like, all right, so you deal with fire claims? Yeah. Do you have premises liability claims? Yeah. You do a structural issue? Yeah. It's like, oh, so you can do it all. It's like, yeah, I've dealt with it all. Well, I don't want somebody that deals with it all. I want the individual who deals with the specific type of case that I have. So ask the right questions, interview them, call them up, consider budget. Of course, if I have a $5,000 case, I'm not going to have an expert, right? But if I have a $55,000 case, I might have a different expert than I would have if I had a $5 million case. So always consider these things. Be careful. Be sure that when you bring in these experts, you're telling them, here's a piece of advice. I've said this a billion times. Never, 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 in my opinion, ask for a written report. Keep everything verbal until you have counsel involved. I never want to see a case referred over to me unless, I'd rather see the case than not see it. But ultimately, I'd rather see a case that has no written report. There's some notes on verbal communications. I can call that expert and I can help them to figure out what we need to prove so that we can get the right stuff in that report. So never, never, never make that note. Ask for a written report until you engage an associate with counsel. Now, beyond that, always consider notice. We always make sure we notice the claims right. A lot of time in slip and falls, another place to note, claims against government. There's going to be a lot of slip and falls, right? Government, sadly, the government owns a lot of property. We see just a totally crazy amount of claims against government entities involving these slips and falls, be it a post office or a local facility or a courthouse, wherever it is. And remember that claims against the government, tort claims against the government, there's sovereign immunity. They are only responsible for what they want to be, what they've agreed to be responsible for. So every state, every jurisdiction has different rules for when the government entity can be liable to you for your injuries. So we need to make sure we're very specific. They also have different notice requirements, right? Some jurisdictions, it's 180 days. Meaning that guess what? If you have a slip and fall, you're just investigating it or you're willy-nilly just letting it go out there and all right, I'll send some demands, see what happens. Guess what? If you don't appropriately notice it, sometimes on specific forms with specific information that must be included within that 180 days, your claim could very well be totally barred. Totally barred. Not just limited in some way, but you just have no claim anymore. So whenever government is involved, whenever there's a slip and fall, an issue with the government entity, I always say just get counsel involved right away so you can make sure that it is being appropriately noticed. And finally, this is our opportunity to handle our insureds. In subrogation, I always like to stress the importance. Slip and falls are probably the most of any other, maybe some auto collisions and disputed auto liability, but one of the most important cases where the insured, the claimant, their testimony, their perspective is of utmost importance, right? Many products cases, we can prove up the case without necessarily having the insured or claimant on board, right? Slip and falls, their involvement largely because of the importance of allocation to contributory negligence, what they did, what they saw, how they fell, how they were injured, they're the only ones that can provide that testimony. So we need to work very closely with our insureds and claimants to make sure they understand who we are, what we're doing, how we're going to be pursuing this. If we're pursuing it through their attorney, of course, we're working alongside plaintiff's counsel. But in the end, it's so important that we handle our insureds and claimants appropriately, explaining the process of subrogation, what we're doing, who we are, how they benefit from our efforts. And that's huge here. I could talk here for another 3 hours about premises liability claims. Of course, I think it's important to note everything we discussed today is not always universally applicable in each jurisdiction, especially as it relates to safe place, those other items. However, you can say that most of the investigation techniques, that's applicable across the board. Just investigate early, often, do it right, don't cut corners. And if you have questions, reach out to knowledgeable experts and counsel. That's the big thing here. So I'm sure we'll have more opportunity in the future to discuss more. You'll probably anybody that deals with these claims is going to see a lot of slip and fall on ice claims. Weather's getting more and more variable over the last few years. We're expecting a winter that's going to be interesting. So definitely stay posted, keep on top of these things, and continue to listen in for more training, more materials on your favorite podcast, my favorite podcast, the Subrogation Support Network. Thank you, everyone, for joining me today. Thank you, Emma, for being amazing at keeping these things coordinated. And thank you again. I'll see you all next time. Ashton Kirsch signing out with the Subrogation Support Network podcast. Thanks.